Welcome to the Deep Dive. Today, we're getting into something that's often really difficult: family, money, and the law, specifically around power of attorney.
That's right. We're looking at a situation based on a legal consultation where a listener suspects their deceased sister might have, well, misused the power of attorney she had for their mother.
And it involves a pretty significant amount of money, right? Like $120,000 allegedly withdrawn without authorization.
Exactly, $120,000.
Okay.
So our mission today is to unpack the legal issues here, especially now that the sister has passed away, and figure out what the potential next steps might be.
Okay, so let's start with the core issue. The listener and their cousin saw bank statements showing this withdrawal. Legally speaking, what does misuse or abuse of power of attorney actually mean, say, under New South Wales law?
Good question. It really comes down to the duties outlined in the Power of Attorney Act 2003 here in NSW. The person holding the attorney, who was the sister in this case, has a fundamental duty to act only in the best interests of the principal, their mother.
Only in her best interests.
Yes. And crucially, they absolutely cannot use that power for their own benefit. So taking $120,000 for personal use, if that's what happened, would likely be a serious breach of that duty.
So it's not just that the money moved, it's why it moved and who benefited. Is that the key?
Precisely. That brings us to something called fiduciary duty. Holding a power of attorney puts you in a position of immense trust. You become a fiduciary.
A fiduciary, okay.
Which means you're legally and ethically bound to prioritize the principal's interests above your own. Always. Any transaction where the attorney benefits improperly is a big problem, a breach of that trust.
And even though the sister has died, that accountability doesn't just vanish.
No, it doesn't. The legal system allows for pursuing that financial accountability against the assets the person left behind their estate.
Right, and that's the big complication here, isn't it? The sister has passed away, so you can't pursue her directly.
Correct. That changes everything procedurally. Any claim isn't against the sister personally anymore. It has to be made against her estate.
Her estate. So the assets she left behind.
Exactly. And this is where other laws might come into play, potentially the Civil Liability Act 2002 in NSW, which deals with claims for damages or losses, like the missing funds.
Okay, and who's handling her estate? I gather it's her son.
That's right. The deceased sister's son is the executor.
What does that mean, his role as executor in this specific situation?
Well, as executor, he has the legal job of managing the estate, gathering assets, paying debts, and dealing with any claims against it. This alleged misuse of funds is now potentially a claim against the estate he manages.
And the listener has already told him about their concerns.
Yes, which is the right first step. The executor needs to be aware of potential issues or claims.
So could the executor potentially sort this out? Or what happens if he doesn't? Could the listener end up needing to take action against the executor himself?
It's possible. The executor has a duty to the estate to manage it properly and lawfully. If there's a credible claim, like this one seems to be, he should investigate it.
And if he doesn't, or ignored it?
If he fails to investigate properly or, say, refuses to address proven misuse of funds, then yes, the listener might have grounds to take legal action against him for failing in his duties as executor. It's where power of attorney law meets estate law.
Wow, okay. Definitely sounds complex. So for our listener right now, feeling overwhelmed, what are the absolute first things they should be doing, like practically speaking?
The very first crucial step is finding and reading the actual power of attorney document carefully.
The document itself, why?
Because it defines exactly what authority the sister had. Were there any limits, any specific rules? At the same time, they need to gather any relevant documents about their mother's finances and the sister's estate. Get the whole picture.
Okay, POA document, estate documents. What about evidence of the withdrawal itself?
Absolutely vital. Those bank statements that raise the alarm are key pieces of evidence. Collect and organize all financial record statements, maybe transaction details if possible, anything that shows the money leaving the account, and ideally where it might have gone.
Is there any sense of how long just gathering this initial information might take?
The legal advice suggested maybe 1 to 2 months for that initial digging and document gathering phase. It depends on how easy things are to find.
Okay, let's say they gather the documents. The evidence seems to support the claim, but maybe the executor isn't cooperating. What happens then? Legal action.
That becomes the potential next step, yes. Formal legal proceedings to recover the $120,000 from the sister's estate.
And what does that look like timeline-wise? Are we talking years?
It's hard to say precisely, but a rough estimate might be, maybe 6 to 12 months. It really depends on the case's complexity, how much the executor cooperates, court availability, lots of factors.
Right. Let's talk brass tacks. What are the realistic chances of actually getting that money back? Does it just depend on whether the sister had assets left?
Largely, yes. Recovery depends heavily on what's actually in the sister's estate. If there are enough assets, property, savings, whatever, then recovery is more likely. If the estate is small or has debts, getting the full $120,000 back might be difficult or impossible.
And pursuing this legally costs money too, obviously. What kind of range are we potentially looking at?
Again, it varies. But the initial advice estimated potential legal costs could be anywhere from, say, $5,000 to $20,000, maybe more if it gets very complicated or drawn out.
That's a significant consideration.
It is. And we shouldn't forget the emotional side. These are family disputes. The stress, the conflict, that takes a huge toll, regardless of the financial outcome.
Absolutely. Okay, so pulling this all together, what are the main things our listener needs to keep in mind? The key takeaways.
Well, first, their concerns are valid and worth investigating. Power of attorney abuse is serious. Second, the sister's death makes it legally complex. It's now an estate matter involving the executor.
Right, it's not straightforward.
Not at all.
Yeah.
It requires understanding both POA rules and estate administration law. They intersect here.
So the single most important piece of advice right now.
Get specialized legal advice. Now, talk to a civil lawyer who really knows their stuff when it comes to estates, trusts, and this kind of litigation. They need someone to look at their specific situation, review the documents, and map out the best strategy.
That echoes the advice from the original consultation. It seems essential here.
It really is. This isn't something to navigate alone.
This has been incredibly helpful, really shedding light on such a difficult, sensitive area. It really highlights the legal tangles that can happen when family and finances collide like this.
It does, and it underscores just how vital those fiduciary duties are, the responsibility that comes with managing someone else's affairs, and the importance of the legal processes designed to address things when they go wrong, even after someone has passed.
Yeah. Thinking about all these complexities, the estate laws, the duties, the potential for things to go wrong, it really makes you pause and consider, doesn't it? How well do our broader systems actually work to protect vulnerable people in these situations and ensure there's accountability? It's definitely something worth reflecting on. Thanks so much for walking us through this.